With me now is the Attorney General, Greg Smith, SCMP. Welcome. The Law Reform Commission has not recommended this. You haven't consulted the Bar Association or the Law Society. Reform of the right to silence rule was not in the Coalition's pre-election contract with the people of New South Wales. You're now proposing this state moves unilaterally on this reform. What is your justification?
Our justification is that we have seen probably an unprecedented number of shootings and other terribly violent acts in recent times. We've been facing witnesses who will not cooperate, and although we have ways to try and compel them to cooperate through the Crime Commission, the fact is that often they are involved in crime themselves, and so we felt that we needed a circuit breaker to really give a chance to the prosecution to get convictions in these cases.
Attorney, the Law Reform Commission said an examination of the empirical data does not support the argument that the right to silence is widely exploited by guilty suspects. Where are your stats? This is a prosecutor speaking, yes, not an Attorney General.
Well, I suppose you're formed by what you've done in the past, and as a prosecutor, I can tell you that I formed the view, and in 2006 I spoke at a Bar Association forum on behalf of the prosecutors supporting this very initiative. And it's funny, it wasn't really contested there.
Well, why would it be with prosecutors? Because
no, but we had a lot of defence lawyers there too.
Can you get some stats? Because you've got to get over the Law Reform's most recent inquiry into this in 2000, I think it was.
Look, we'll be circulating the bill, the draft bill, within the next week or so, and we'll be giving time for submissions to be made. So it's not as if they wouldn't be consulted. Generally, legislation hits the deck for the associations when it's introduced. We'll be giving them a month to respond, and that should be enough. They're all geared up now, and that's how we'll be dealing with that.
Evan Whitten says heavy criminals do use the right to silence to avoid justice. He reckons about a half of those who currently hide behind the right to silence escape justice. What's your guesstimate?
Well, I wouldn't make a guesstimate about it, but I'd say it's quite common. Certainly in cases I ran myself in trials and in appeals that I was involved in, it was quite common for the accused not to come up with his defence till very close to or at the trial, without having said nothing in the first place. Now, if they said something different in the first place, we'd gun them down, as it were, because they'd be convicted on their lies.
Name the guilty criminals who've got off using the right to silence.
Well, I can't.
You can't, can you? Because to do so would be to undermine public confidence. But the fact is there are guilty criminals out on the streets of New South Wales and Australia who'd use this tactic.
That's right. And I don't object to the idea that guilty people get off as long as innocent people are not convicted. That's an old legal statement, and it's a correct one. But just as when the doc statement was abolished in this state, when people used to be able to give an unsworn statement, the cries went up as if the world will all be ruined, says Anne Rahan. Just as when the Evidence Act came in and put in some balances, some supporting the prosecution, some supporting the defence, there were all sorts of outcries. Things settled down, and in this case, anyone who's innocent will not fear this problem. 99.9% of people won't have to fear this. It's the guilty that might have to fear it.
What about the point that we need safeguards, particularly for the mentally ill or Indigenous Australians? So the legal aid lawyers say, whatever you do, if the cops pull you up, say nothing. Say nothing, because you could incriminate yourself if you say anything.
Well, no one will be forced to incriminate themselves, so there'll be no change to the right to silence in that respect. I'll be recommending that it not apply to juveniles up to about 16, for people with mental disabilities and certain other categories. So, and there'll be the answers or the non-answers won't be admissible against you unless you have the opportunity to get legal advice. So that's the great
Will you, like the English do, the British and Wales, provide a duty solicitor at all those police stations that are equipped to do video police interviews?
No, we won't, but we will make legal advice available, often over the telephone, but they'll at least have an opportunity to get legal advice. So unless we do that, the changes will not help any prosecution case.
What about Philip Bolton's point that when a suspect is interviewed by police, he or she doesn't know what they're facing, the police are on a fishing expedition looking for evidence and can use the interview to coerce or lead suspects into self-incrimination?
Look, I'm an admirer of Philip's forensic skills and I think he is prone to exaggeration on this matter. And I don't believe it's as bad as he makes out.
What about your reputation as a law reformer attorney? The District Court in Armidale has just recently released a 21-year-old disability pensioner convicted under your new anti-bikie consorting laws because the judge found it was unsafe at this stage. The outlaw motorcycle gangs must be laughing at you tonight.
Well, I don't think they are. I think the outlaw motorcycle gangs are looking over their shoulders all the time, because they're under siege at the moment.
You stand by the consorting reforms that you introduced?
I do, and I think they've been very effective. And the main thing is they're safeguarding our community against people that don't respect their lives.
Greg Smith, thanks very much.
Thank you, Quentin.